and welcome to a Newsflash episode of Unpacking the Case, the podcast by Davitt Jones Bould, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie. How are you?
Very well, thank you. Lovely new jacket you've got on today.
Oh, thank you, but people
you didn't even prime me to say that.
People shouldn't say that on a podcast. I might wear them.
You'll just have to visualise it.
Of course, next week.
So we're here to talk about a High Court case from the 13th of June called Atkinson and Others and Browne. And quote unquote, it's about everything under the sun. So I'm going to hand straight over to you so you can explain the background to this one.
It's a High Court decision. So I'll tell you the background facts as we usually do. It's a place called the Hockering Estate in Woking in Surrey, which was built in about 1910-11 and has 95 properties on it, sort of private roads and private estate. And there was a predecessor managing the estate, the Hockering Residence Committee, that was the predecessor to the current management structure, the Hockering Residence Association, which the various homeowners, property owners and the likes will become members of the association to manage things like the private roads and verges and this kind of thing. And sounds very exclusive, actually. Lord Templeman, the famous judge, used to live there in the past, apparently. Mr. and Mrs. Atkinson bought a property there called Upper House in 2012. And another person who was complaining about the Residents Association, Mr. and Mrs. or two people, Mr. and Mrs. Browne, bought in 2015. Both of them became members of the association, which is significant to one part of the decision. I mean, what then happened is disputes arose. Firstly, the Atkinsons wanted to build an in and out drive, if you know what one of those is. It's basically you have two gates. I have one. So you don't have to suffer the indignity of having to reverse and such likes. So you can just drive in and out. And they wanted to do this. And there was various restrictive covenants from various dates, but going back to 1911, which required consents and the likes of the Residents Association. And the Brownes had a different dispute about various works that the Residents Association was doing on the verge outside their house. And that's what gave rise to litigation, several situations. I mean, it brings in, like you say, many areas like enforceability of restrictive covenants against subsequent purchasers. It brings in presumptions as to where boundaries are, and it also brings in adverse possession, specifically in relation to trustees and whether trustees and unincorporated associations can claim. There's been cases over the years on that which don't have too much in the way of clarity, it must be said. So, shall we deal with them one by one?
Yes, please.
Well, firstly, the restrictive covenants. I mean, we've mentioned this over the years in courses, we've done podcasts on this galore. But once the parties get involved, restrictive covenants, the benefit and burden must pass to covenantee's successor, the person with the benefit, and the covenantor's successor. And the way the benefit passes to subsequent people, here the Residents Association, is, well, you can either annex the covenants to the land, you could create a building scheme where everybody in the scheme is bound by the covenants and enforce against everybody else. Or you can specifically assign every time you go through a transaction, you go through another assignment. It was accepted, there wasn't a building scheme, and I think we were well advised to accept that, and it was accepted, well, there were no assignments, so they were left with annexation. And if you want to go through an express annexation of the covenants, then, well, there's cases galore. I mean, the major case, the first starting case was a case called Rogers and Hosegood in 1900, which I don't think was quoted in the report. But you basically have to identify the land and state that it passes, it's for the benefit of successors. If the covenants were created from January the 1st, 1926 onwards, when the Law of Property Act came into force, Section 78, they're deemed to pass with successors, but you still have to make clear what the benefited land is. And there's always been an issue with benefited land, that the land registry tell you what the burdened land is, but they don't tell you what the benefited land is. And if you're not careful, you might actually lose all evidence of the benefited land. And you remember we did a case right at the end of 2021, a Court of Appeal case, Bath Rugby Club in Greenwood.
Yeah.
About the Bath Rugby Club, where it was stated that it was not to commit a nuisance or annoyance covenant, which was created in the early 1920s, and it said it was for the benefit of the inhabitants of the Bathwick estate, which is the area around the rugby club, which is where I used to live, not in the rugby club, I didn't live there, but nearby. They also mentioned the benefit of successors. But the Court of Appeal said you can't just have a generic description, you have to clearly identify the land that is benefited. And so the covenants wouldn't pass wouldn't be annexed to the land. And in this particular case, they didn't have any evidence of what the benefited land was either. So the covenants, the benefit didn't automatically pass. So the covenants weren't enforceable as restrictive covenants. But the court went on to say that because the Atkinsons and the Bremers had become members of the Residents' Association, then they were bound by its constitution, contractually bound, and therefore they could still enforce against the Mrs. Atkinson and Mr. and Mrs. Bremer. So that dealt with the restrictive covenant side of things. They weren't enforceable against subsequent purchases, but it, to all intents, didn't matter because they were contractually enforceable. So that was the first point.
What else is there?
Well, they tried to argue that it's a presumption as to where boundaries are. There's several presumptions as to boundaries, but specifically, it's ad medium phylum presumption. Do you know what that is?
No.
We've mentioned that in these courses before. There's a rebuttable presumption that if you own a property adjoining a road, then the rebuttable presumption is you own to the middle of the road, and the person at the side of the road will own to the middle. Ad medium phylum. Same with rivers and the likes as well. But it's only a rebuttable presumption. So they were trying to argue that this work on the verge and the likes, it's our land anyway, and the sort of the separate access way to the house. Court made clear it depends on the circumstances. It's a rebuttable presumption. There's a few cases over the years on it. There was a case back in the 19th century, in 1872, called Beckett and the Corporation of Leeds, that said if such a presumption arose in relation to estate roads, it would cause chaos, it would be very inconvenient. And there was a more recent case, albeit from 1977, called Giles and County Building Contractors of Hertford, which had said that if the boundaries are not known, if there's no evidence of the history, of the conveyances and the likes, then the presumption might apply. But if there's evidence of history of the conveyances, which is what the case was, in this particular case, then the presumption wouldn't apply. So they decided in the circumstances there was no presumption that you owned the midpoint of the boundary. So the Residents' Association won that part of it as well.
Is there more?
Yes, there's more. Adverse possession was the other one. What had happened, in 1986, I think I said that the Residents' Association took over from the previous Residents' Committee this particular land, the private roads and verges, and they applied for registration through adverse possession for the roads and the verges and the likes. And the land registry registered them with a possessory title. This was back in 1987. And the Atkinsons and the Bremers were trying to argue that, they shouldn't have, it was a mistake to register back in 1987. But the court decided you've got all the requirements for adverse possession. There's been a lot on adverse possession. We've done several podcasts on this year.
Yeah, it has.
Yeah, there's got to be a factual possession and an intention to possess the land. You've treat the land in the same way as if it's your own land, and you intend to exclude all others, including the paper owner. We did a case not long ago called Kirkman and the Bradshaw Pub Company from West Yorkshire, which said that fencing is not essential. For instance, if you can't easily put up fencing and gates on the on the land. There's obviously no fencing as such, throughout the whole of these private roads. But what they'd done, no later than 1963, they'd done things like they'd employed part-time people to sort of maintain the roads, these private roads, and fill in the potholes and the likes, and clear snow in the winter time where appropriate, and replacing gates, tidying up the verge, and so on. And putting signage up, 20-mile-an-hour signs and the likes, and maintaining them. And felling trees was another. And the court decided that was clear evidence of adverse possession, factually possessing the land, treating it as if it's your own, and intending to possess the land, a corpus possessionis and animus possidendi. But the last issue was, can the trustees of this residents' association actually claim adverse possession? Can unincorporated associations claim adverse possession? And there's been quite a lot of cases, as I mentioned, on that over the years. There was a case in 1883 called Norwich Corporation and Browne, which had said that the members of a parish with no connection with one another, for instance, couldn't claim adverse possession. But there'd been a case called Holland and Neville Estates in 2006 that said sort of corporate bodies can collectively claim, on behalf of everybody, can claim adverse possession. There was a case which wasn't mentioned because it went against that, a 2013 case called Openshaw and P&F Properties, which said that it was a fluctuating members of this, this body, and therefore they couldn't claim. And there was a Privy Council case, they cropped up in a few cases lately. Eleuthera, basically it's Bannerman Town and Millers and Jonathan Miller's Eleuthera Association, and Eleuthera Properties, which is in the Bahamas, which said what you've got to look for is some kind of collective, if you like, sort of common purpose, shared purpose, and therefore you could claim adverse possession. They decided in this case the trustees could claim adverse possession. Trustees can claim adverse possession if there's some collective purpose. And finally, there doesn't have to be an express declaration of trust. The fact that this property was vested in the residents' association and therefore the trustees was sufficient. So with the restrictive covenants issue aside, which proved not to be costly, that was the decision. Browne and the other trustees win.
So what's the significance of this one, do you think?
Well, it's a good illustration. I mean, the fact that trustees can sort of, with a common purpose, claim adverse possession is something quite significant. But there has to be that common purpose. The fact that the ad medium filum, is just the presumption, always needs to be remembered, and it's not difficult to rebut the presumption. I mean, it also applies in relation to adopted highways. It's just the the material and scrapings, as they say, that are adopted, but down below there is a presumption as to ad medium filum, but it can easily be rebutted. And it's a reminder that restrictive covenants, you have to make clear what the benefited land is, and that there is some benefited land as well. You didn't own any land nearby, then there's no benefited land anyway. So it's a good reminder of several areas, actually.
Excellent. Thank you very much, Richard.
My pleasure, Lizzie.
Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.